right, I think we're good. Well, welcome everyone to UnitedHealthcare Global regulatory presentation designed to help you navigate the ever-changing landscape of international health insurance. My name is Global Greg Ruggiero, and I'm pleased to share the stage today with my esteemed UnitedHealthcare Global colleagues and partners to bring you the latest updates from around the world. Before we begin, I would like to extend a thank you to everyone who helped organize this, including many internal departments here, and would also like to thank all of you. The response to this went beyond our expectations, and we very much appreciate your attendance and participation. Today, we have three main topics, starting with recent changes in the expatriate insurance requirements in the Middle East. Then we'll dive into the emerging rise of digital nomads and what this means for international insurance plans. And we will then finish in the US with an update on state consumer privacy laws and the impact on expatriate and travel medical plans. The topics today will be covered individually by our exciting lineup of speakers who will be sharing their valuable insights. As mentioned, I'm Greg Ruggiero, working in client development based in NYC. We have Sarah Dubinsky, Senior Associate, who'll be covering the Middle East. Greg Williams, Associate General Counsel, who will take us through the landscape of digital nomads. And finally, Senior Associate Eric Greenberg, who will update us on US privacy laws and the impact on expatriate and travel medical plans. We also have Sabrina Bienu, our National VP of Sales, who will be monitoring the chat and Q&A. Sabrina, how you doing?
Hi, I'm here. Welcome, everybody. Appreciate the attendance. Thank you.
Very good. And lastly, some housekeeping and reminders. If you have any questions during the presentations, please submit them via the Q&A feature. We'll address as many questions as possible at the end of each speaker's presentation. Please note that all attendees are made on mute and your camera will be disabled for the duration of the webinar. Also, I'd like to inform you that this webinar is being recorded and it will be sent to all registrants afterwards. Now, without further ado, let's dive into our first topic, mandatory health insurance requirements for the Middle East. Please welcome Sarah Dubinsky.
Hi, everyone. As Greg mentioned, I'm Sarah Dubinsky. I'm a Senior Associate General Counsel with UnitedHealthcare Global Solutions and going to provide a brief update to you today on some of the changes in the regulatory landscape in the Middle East, particularly around the introduction of mandatory health insurance requirements as applicable to expatriates and, in some cases, travelers to the regions. So I think it is fair to say that the healthcare landscape has seen a number of changes over the year, particularly with respect to the introduction of these mandatory health insurance requirements. And it's important for employers and their consultants to understand these changes, not only from a compliance perspective generally, but also because they are very much tied to immigration. And if an employee doesn't have the requisite coverage in place, they will not be able to obtain or retain their work visa. As many of you probably know, there have been similar requirements in place for quite some time in the UAE, and specifically in the Emirates of Dubai and Abu Dhabi, and also in the Kingdom of Saudi Arabia. More recently, we've seen a lot of activity in Qatar, and these requirements also are very much on the horizon in Bahrain, Kuwait, and Oman. And there are two primary reasons for these requirements. The first is essentially to alleviate pressure on the local healthcare systems. In these jurisdictions, expatriates make up a very large portion of the population. So for example, in Qatar, they make up 85 to around 90% of the entire population. So there's a real government interest in ensuring expatriates have adequate and substantial coverage, and that there are no gaps in coverage, and that providers are paid in a timely manner. This has sort of always been an issue, but it was definitely exacerbated by the COVID-19 pandemic. And we've seen regulatory activity introduced as well in light of that. The second reason is less publicized, I would say, and that is health insurance is also seen as a potential growth engine for the local economies. And many of these requirements essentially state that the insurance can be provided by a locally licensed carrier only. And that, of course, in turn generates revenue for both the local insurers, but also taxation revenue for the government. I'm going to start talking about Qatar. There's been recent activity in Qatar that applies to both expats and international travelers. A mandatory health insurance law was first passed in Qatar in November of 2021. So as you can see, that was not too long after the beginning of the pandemic. The law does require employers to enroll their Qatari expatriates and their family members into health insurance coverage provided by a locally licensed insurer and a company registered with the Ministry of Public Health. There are substantial penalties and fines that can occur to the extent they do not. Fines can range anywhere between QAR, that's Qatari Riyal, 30 to 500,000, which translates roughly between 8 and 140,000 US dollars. This coverage is required for both visa applications, for resident permanent applications, and this law was not in effect until May of 2022. And still full details of how this law will be implemented are still not known. However, our business has been very proactive in ensuring that our expatriates in the region will be able to obtain the necessary coverage. We've actually entered into a partnership with a company called QLM, and that is Qatari Life and Medical Insurance Company. QLM is the leading health insurer in the region, and it also has a very vast provider network. So we're pretty excited about that. Also, in relation to international travelers, around this time last year, it was on February 1st, there was an announcement by the Qatari government that international short-term travelers to the region would also require health insurance procured from a company that is registered with the Ministry of Health in Qatar, and that can be purchased through the ministry's health portal. This coverage is necessary to obtain a visitor visa. The coverage is fairly inexpensive. It's around $14 a month and generally provides coverage for emergency medical treatment. I'm going to touch quickly on Bahrain. There was a compulsory health insurance law passed in Bahrain in 2018. As you can see, things take time in the Middle East, and we're sort of still waiting to see what happens with this. It does require that coverage will ultimately be provided by a locally licensed carrier. And the scheme is referred to as Sahati, and it will be implemented for expats, locals, and travelers. It was expected to be implemented by the end of this year, but there will be delays. And this is one of the reasons why we maintain a very extensive watch list with our external counsel in the region so that we can be updated regularly when things happen. In Kuwait, the situation is somewhat the same. Kuwait has talked about introducing mandatory health insurance for foreigners entering on commercial visits or work visas for quite some time. The primary goal is to reduce pressure on the local healthcare system, particularly as health services for expats have historically been free of charge. More recently, there have been some announcements by the government that expats will see costs raised for certain services, and in some cases may be restricted from accessing medicines. But we're still very much waiting further updates on how things will be implemented. In Oman, the story is not too dissimilar either. There's continued delays to the introduction of mandatory health insurance there as well. The insurance regulator, the CMA, otherwise known as the Capital Markets Authority, did issue a decision a few years back that kind of described the mandatory benefits that will be required when these policies become sort of required there. But still no firm sort of regulatory activity in terms of when things will actually be implemented. The regulator has taken steps to set up a centralized management system for insurance claims. That's called Damani. So that has been set up. That will be tied to the mandatory insurance requirements, but still no real activity there at the moment. And we will continue to monitor activity in this region and update our clients and brokers when things happen. And one of the methods we use to do that is our quarterly legal executive briefing. So keep an eye out for that, because we're frequently communicating regulatory updates in that publication. And with that, I will stop and see if anyone has any questions.
Hi, Sarah. We have one question. Do you anticipate more countries around the globe will follow suit and do what the Middle East has really leaned into in terms of requiring a local insurer?
It's quite possible. I think the Middle East is somewhat driven by the fact that expatriates take up a very large portion of the population, but that's not too uncommon, right? So as pressures increase on the government, they'll be looking for ways to ensure that the expat population doesn't essentially become a burden. So I do think it is possible, absolutely, outside of the Middle East.
Okay, fantastic. We don't have any other questions, so I'll turn it back over to Greg.
Thank you.
Excellent. Yes. Thank you very much, Sarah. And yes, please look out for the executive briefing. It is sent out quarterly. It should be sent out by your regional client development representative. So now let's move on to our second topic, emerging rise of digital nomads and key considerations for international insurance plans. We have Greg Williams sharing his expertise. Greg, all you.
To move my actual microphone to my face, that'd be helpful. So thank you, Greg. As Greg said, I'm Greg Williams. I guess part of our value proposition is you get 2 Gregs for the price of 1, but don't think about it any more than that, because this is a complimentary seminar. So I'm going to be talking a little bit about the rise of digital nomads, and what you see on this slide generally is something that should be seen as a mental checklist for those of you that are brokers out there that have clients that are looking to implement some form of work from anywhere policy. They're not all benefits related, but as you'll see, they're all kind of interrelated. And so generally speaking, the rise of digital nomads, like many things in our current landscape, come from the COVID-19 pandemic. And a lot of people, after, cities shut down, were working from home, and likely had the thought that, let's say they're a Silicon Valley worker and they're working remotely from their East Bay home. And they probably had a thought that was like, well, all I need is an internet connection to do this job. Why do I need to be in the same area when I could do it from anywhere in the world? And so the digital nomad, well, it was a term that's been coined for a while, really kind of came into focus for a lot of folks. And it is kind of funny that, the reasons that a lot of digital nomads make the decision to become digital nomads is maybe they're seeking something like they want to go to be closer to family, or they want to experience a less expensive area of living from a high cost of living area that gives them the same quality that they have where they are. Or maybe they want to go to where they've always wanted to explore. And it's always funny to me because nomads are traditionally folks that are following their livestock to new pastures. So we literally are building this around the idea of folks that are looking for where the grass is greener. So the first thing I want to talk about is immigration. This is not an area, whenever you're doing work in a foreign country, you have to keep in mind that a tourist visa is not going to allow you to work at all. Doesn't matter if you're a freelancer or working for a multinational corporation. If you are working in a jurisdiction, you can't do it on a tourist visa. So typically you have to have some sort of work visa to be there. And oftentimes, at least previously, that required an employer sponsor. More and more, we are starting to see the rise of these digital nomad visas that are trying to attract people to different countries. This is something where it's always important to worry about because both the employee and the employer can be found liable if they break any laws related to immigration. And some of the countries that are trying to seek out digital nomads are making it a little bit easier. So they might have like really low bars to entry. So maybe you have to pay a fee. Maybe you have to prove that you're going to have a certain amount of income while you're in country, clean criminal record. And typically you need to also show that you have some form of not only health coverage, but health coverage that can also get you back to your home country if required. Another piece is the governing law and employment rights. So typically, just by changing jurisdiction, that isn't going to change the employee-employer relationship that the employee already had with their employer. So if there's a employment contract or some other governing document, that is going to continue to apply. But it's also likely that not all protections or pieces in that employment contract is going to be enforceable in the new jurisdiction. So the host jurisdiction, so where the employee is, has a vested interest in having their law be enforceable locally. And so, when you think about it, that makes sense because the employer or employee is physically located there, and there might be some rules and regulations that will either not be enforceable by the host jurisdiction or might be enforced against the employer by the host jurisdiction. So it's something that everyone needs to keep in mind. And something that's really important in all of this is that the length of the stay definitely matters. So if someone is only going to be going for maybe 3 months, it's a little bit less likely that local laws are going to apply. Doesn't mean that they're not, but the nexus is still relatively small. Compare that with somebody living in a host jurisdiction for 2 or 3 years. And I think of the digital nomad visas, I think the longest one I've seen is about 24 months, so we can use 2 years. It's more likely that local laws are going to start to apply. And always remember that there is that vested self-interest in the part of the host jurisdiction to enforce their laws locally. You can't get away with something that would otherwise be illegal just because there's an employment contract in a foreign jurisdiction. And also keep in mind that there might be different rights that employees have in that jurisdiction, in the host one, because maybe there is certain requirements that Social Security be contributed to. Maybe there are certain requirements related to how you can hire and fire people. So it is very important that your clients are aware of these kind of jurisdictional gymnastics that might occur. Certainly important to everybody on this call is going to be health and safety obligations. So just like anywhere else, employers are going to have a duty of care towards their employees. And a lot of these jurisdictions are going to require some form of health cover. And probably not just some, all of them are going to require it. But it's not always going to be a clear-cut case of maybe the domestic plan that they have back at home working. It could be something where some jurisdictions, for instance, the Cayman Islands as an example, require that the employee have coverage, not only local health coverage, but one that is approved by SEMA, which is the Cayman Monetary Authority that monitors all insurers. And so in that instance, even a global expatriate plan might not fully get the job done, though there are certain ways that that can be done, or at least they can work in concert. But there are jurisdictions that are going to have their own specific rules regarding who can cover what and in what circumstance. And I think as Sarah mentioned in her presentation, the Middle East is another example of that, where you might have to enter into a partnership with a local insurer to make sure that you can cover people that are there. There's also the idea that you also have to think about repatriation. So if this employee ever has to return home, you have to make sure that their health coverage is continued when they return if they, for instance, left their domestic healthcare plan. There's also an obligation to make sure that the same health and safety requirements that you'd enforce at home are applicable abroad. So if you had employees that were working out in the field, don't necessarily know how much that's going to apply in a digital nomad circumstance, but you still have an obligation to keep them safe, and you being the clients and employer groups. Most important, especially when it comes to your clients, is going to be tax considerations. And that is because it is an area where the employer can find itself with probably the most unexpected and undesired consequences from a globally mobile digital nomad employee. It's always the responsibility of the employee to determine what their own responsibilities are going to be for local taxes, though an employer might have some form of obligation to, for instance, make deductions for local taxes or Social Security or pension. And so it's something to keep in mind. Something else that's really important is that employers certainly want to make sure that they are not having any conduct that gives the impression, whether generally or legally, that they are establishing kind of like a quasi branch in the host jurisdiction. Because if they do, they can be brought in and perhaps made to pay corporate tax. And again, this is one of those areas where the length of a stay does matter, because at some point the host jurisdiction is going to want to charge taxes, and certainly the employer does not want to get dragged into that. There's also engaging entity limitations. So in some jurisdictions, it might not be possible for a foreign employer to engage labor, whether it's local or non-local. You might have to go through, or an employer might have to go through a staffing company or some other form of employer of record sort of arrangement. And so they might not even be able to keep that direct relationship. And again, it is an area where if they tried to create one, you would possibly end up with that inadvertent creation of a branch, which would not be good. Finally, there are data protection and IP issues that could be at stake. As everyone's aware of, there are a myriad of global data protection laws that protect personal information throughout the globe. And if an employee is located in one of those jurisdictions, the employer is going to have to be pretty careful about how they store and transmit any information pertaining to that employee. Or if they're in an industry where there might be others' information, realize that they're either importing or exporting that data. And finally, with IP, there could be issues where intellectual property related to the employer is not protected in the same way, or maybe doesn't vest in the same way as it does in a home environment. And so this is, again, the fastest possible way of going through this, and not really trying to solution anything, but more trying to give you all a sense of what to think about when you have clients that come to you asking about how this would work. And the joke is that whenever somebody asks about this form of policy at work from anywhere, there's a specific question as to whether or not an employee can work in location XYZ. The answer, at least from your legal teams and the legal teams of your clients, is going to be, it depends, because this is always going to be a fact-intensive question that is going to differ in nearly every jurisdiction. And that is the quick rundown of digital nomads. See if we have any questions.
Thanks, Greg. Do have one question. I know you just referenced that, a lot of times the answer is going to be it depends,
Mhm.
simply because of the country people are looking to go to. But the question is there usually a quote unquote safe amount of time um, for a digital nomad to um, so that they're not bumping up against this consideration. So, in other words, if somebody on this call had a client contact them and had some questions about digital nomads, if you look at just tax, for example, is there a safe time that somebody could be in country without running afoul of these issues?
So there isn't a hard and fast number that I would consider safe because some jurisdictions might, make it unsafe on day one. Typically, 183 days of an individual being resident somewhere can create, issues for tax residency. So I think that is a good number to think about, but I would caution that it is not a hard and fast rule. It is one that, the risk starts to greatly increase after that point, but doesn't mean that there wasn't risk before that. So you might have a massive increase in the risk after 183 days, but that doesn't mean that there was no risk to start with.
Okay, all right, good enough for a little bit of a guideline there. No further questions. Thanks, Greg.
Thank you.
All right. Well, thank you very much, Greg. And yes, 2 for the price of 1. Can never have enough. For our final topic on U.S. regulatory landscape and state consumer privacy laws, please welcome Eric Greenberg.
Thank you, Greg. Hi, everyone. Eric Greenberg, and I'm legal counsel in our privacy team. I support our UnitedHealthcare Global business. And today we're going to talk a little bit about the evolving landscape of U.S. state privacy laws and the impact on international business and expatriate insurance products. So just to set the table a little bit, I think as most folks on the call know, we don't currently have a comprehensive federal privacy law. We have, in the US, we have essentially sector-specific privacy laws at the federal level. HIPAA is probably the best example, which applies fairly broadly to the healthcare sector. But we don't have a comprehensive federal privacy law. There have been discussions and certain initiatives in Congress, but we haven't had real traction yet. And so states have recently, in the past couple of years, essentially taken matters into their own hands. And it really started with California, which often sets the trends with these types of things, but they were the first state to pass a comprehensive state privacy law back in 2018, which actually was enacted through a ballot initiative. California is one of the states that allows laws to be enacted through a ballot initiative. Many of the concepts and requirements in the California law, the original version was called the CCPA, were modeled on GDPR, the European Union data privacy law, which had recently gone into effect. There were changes made to the California law. The new version is now called the CPRA, but California really set the stage. They were the first state to do it, and we've had a number of states since then that have passed their own versions of consumer privacy laws, and we'll talk about sort of where we are in the landscape now. So this is a snapshot of essentially where we are. It's evolving for sure, and it's rapidly changing. We now have 5 states that have laws already in effect. If you look on the left, California and 4 other ones. We saw a number of states that enacted laws last year, and over on the right, there's a number of states where laws have been passed and signed into law but not yet effective. And you can see the effective dates, some of them go into effect this year, and then the following years after that, we have more. So this list continues to grow. There are other states that are probably going to pass their own versions of a consumer privacy law this year. So we expect this list to grow for sure. This is just a map view, so you can essentially see these states where we have laws that are currently in effect and laws that are passed. We do highlight Florida. It passed a consumer privacy law, but it's narrow in scope. It's really targeted at larger tech companies. So it's different from the other states generally, which have a broader impact. And then New Hampshire recently passed a law, but it has not yet been signed. But again, this landscape continues to evolve, and we have to continue to monitor it. So where does that leave us and leave companies in general? Well, we have an increasingly complex patchwork of state privacy laws. So far to date, we're counting 14. Each state has somewhat different requirements. Now, there are certainly broad similarities between the state laws, but they also have differences and nuances in some of these states. And then on top of that, you have different effective dates to deal with as well. So it's certainly challenging for companies that may be subject to these laws to continue to monitor and implement as these states continue to add to the list. So one of the key questions for companies to consider is whether any of these state laws apply. And each state, again, has differences in terms of applicability and when the state law is triggered. But there are some key questions to ask. And if the answer to any of these questions is yes, then it is possible that one or more of those state laws is going to apply, including whether the entity does business in that particular state, marketing or targeting residents in that state is sort of a key trigger. Some states have a threshold in terms of numbers of residents in that state. Not all do, but some do. 100,000 individuals is a threshold we see in a number of these state laws, but again, not all of them have that. And then some states have a revenue threshold. And if the answer to that is yes, and sometimes in combination with other factors, the law can be triggered. And again, to go back to something Greg said, it's often, well, it really is fact specific, right? And since each of these state laws are different, each business has to look at the individual state law and determine whether it applies. As part of that analysis, right, once a company has gone through that sort of initial review and determined that a law is potentially applicable, then one of the key things that should be looked at is whether there are any exemptions that apply. We've listed out some of the main exemptions here. These are not all of them, but these are some of the main ones. And they include data that is subject to HIPAA. Another exemption is for HIPAA covered entities. Some states, and this is where it gets a little bit tricky, but some states have an exemption for the data at the HIPAA level, and then other states have an exemption for the covered entity itself under HIPAA. There's also an exemption that most states have for GLBA data. GLBA is the Gramm-Leach-Bliley Act, which applies to financial institutions. And then generally, most states have exemptions for B2B data and employment data, but California is unique in that it does not have those exemptions. California is the most consumer friendly of all of these laws. So that's something that companies need to look at as part of their analysis, right? Is whether any of these key exemptions apply. So after an entity has determined that one or more of these state laws apply, then really it needs to look at, okay, what are the compliance considerations? What are the requirements that these state laws have? And again, there are certainly differences, but there are broad similarities, and we've articulated some of them here, and we'll talk about them. But these are really focus areas that companies need to look at in terms of building a compliance program. And there are considerations around this as well, because companies essentially have a few options when it comes to compliance. They could either choose to do it at a state-by-state level, and some companies choose to do that. That can get a little bit complicated. Other companies may choose to essentially take the most stringent approach for that any state has, and then apply it broadly across all of the states. That's the approach that our company ultimately took, is really looking at, well, for each of these areas, what is the most stringent and strictest requirement? In most cases, it's California, and then really applying that across all the states where we have impact. So we'll talk about these key compliance considerations, including individual rights, a requirement to provide notice to consumers. There are certain requirements around contracting, and this largely applies to vendors, data security, and then there are considerations around data governance and the ability of companies to process data. So individual rights, really all of these states provide consumers with certain individual rights over their data. And this is a key concept that ties to GDPR and many other global privacy laws, which we've seen since GDPR. We're really giving consumers rights over their data, and companies have to be able to comply with consumers that request to exercise their individual rights. These are really the key individual rights. The right of access, which essentially means that consumers have the right to obtain copies of their data. The right of deletion, which doesn't apply in all instances. There are a number of exceptions to that, but generally consumers have the right to request that their data is deletion, and if an exemption does not apply, the business has to comply with that request. The right to correction, which means that a consumer has the right to ask a business to correct their data if they feel that it's inaccurate. And businesses, if the data is inaccurate, businesses have to correct it. And then there are a couple of other individual rights. We won't go through all of them, but these companies really have to be able to build a compliance program that that can respond to individual rights and that can comply with all of these rights that consumers have. Transparency and notice is another key compliance consideration. Really what this means is that businesses have an obligation to be transparent with consumers around how they use, collect, and disclose their personal information, their personal data. And part of that transparency is the requirement to provide consumers with a notice. We see a similar requirement under HIPAA, right? But there's that obligation to provide consumers with a notice that is very clear around how the business collects the data, how it uses it, who the recipients of that data may be, and so forth. pretty much every state has a requirement that a business that is subject to that particular state's law has to have a contract in place with certain third parties. And generally, this requirement applies to data sharing with vendors, which are known as processors in most of these states. But there are some states, such as California, that go beyond vendors. So in California, if you are sharing data with non-vendors, in some instances, you have to have a contract there as well. And then there are very specific requirements around what has to be included in those contracts. And again, typically these are vendor agreements, including the types of processing, the instructions. The business has to be very clear with the vendor how it can use the data and so forth. And this all has to be baked into the contract. Data security is another consideration. Companies have to take reasonable measures to secure personal data, and those measures have to be appropriate to the scope and size and scope of the company, the volume of data that's in play. So these security requirements are not very specific that the states have, but companies do have to take this seriously and look at security measures and be able to demonstrate that they have analyzed and they continue to analyze their security posture, and that they have reasonable and appropriate measures in place. Another key consideration under these state laws is the ability to process data, and there are a number of components to this. Personal data that companies collect should be for a specific identifiable purpose, and that purpose, to tie back to the notice requirement, that purpose should be articulated in the notice that they provide to consumers. The data should only be retained for as long as necessary. And once that period has passed, businesses should not be holding on to that data any longer. The business generally cannot use data for secondary purposes unless specific consent is obtained from the consumer. And then we have the data minimization concept, which again is very similar to HIPAA, where companies really should limit the collection and use of data to only that which is strictly necessary. Another consideration is data governance. We have a requirement under these state laws that companies conduct and document what are called data protection impact assessments, or DPIAs. And this is a concept that we actually don't see in HIPAA, but we do see in GDPR. And really, it's a requirement that companies look at certain types of data processing activities, and generally it's activities that involve what are called higher risk activities. Typically that will involve things such as processing health data or genetic data, or certain types of data that inevitably will involve higher risk. Companies need to conduct an assessment and then document how ultimately where they landed in terms of an assessment, where they compare the benefits of processing that data and weigh it against the risk to the consumer rights. So let's talk for a few minutes about sort of what this means in terms of international business and businesses that provide services to expatriates such as ours, such as UnitedHealthcare. So really, we talked about some of the triggers for when these state laws are going to apply. They're all different, but there are some similarities. Generally speaking, if a business is operating in one of these states, if it's targeting or marketing, providing services to consumers in these states, it's likely these state laws are likely going to be triggered. Again, you have to look at each state because they're different in terms of when they apply, but sort of looking at it very generally, if you're operating in a state, if you're providing services to consumers and you meet the threshold, those laws are probably going to be triggered. And those laws can apply to not just US companies, but companies that are outside the US that provide services to consumers in those states. On the expatriate side, again, many of these states, the trigger in terms of applicability looks at whether services are being offered to residents in a particular state. And so companies that provide services to US expatriate travelers, those expatriates often maintain residency in these states when they go abroad for a particular period of time. And so companies have to look through that, think through that as part of their analysis, and ultimately determine whether these particular state laws apply, and think through that in terms of the expatriates potentially being and continuing to be residents of these US states. That can be a complicated analysis. It's one that we went through on our end. And so here on this slide, you can see our products that we have for US expat insurance, and then our global travel insurance. Some of these products are subject to HIPAA. So our core products for expat insurance, medical, dental, vision, they are subject to HIPAA, and our global travel insurance, our business travel product, is subject to HIPAA as well. And because of the HIPAA exemption that these states have, those particular products are carved out, so they are not subject to these state laws. But we do have some products, AD&D, long-term disability, and life insurance, that are not subject to HIPAA, and ultimately we performed an analysis on those particular products and concluded that these state laws did apply. And so this is going back to when California first implemented that law. We put a comprehensive program in place to ensure that we comply with these state laws. And we continue to monitor developments in this space because, again, the landscape is rapidly changing. The good news for companies that operate in this space is if you've developed a compliance program and you've built a foundation, so if you had to comply with the California law and other state laws along the way, which is what we had to do, by now you've probably built up a fairly solid compliance program, a good base. And then as these states, as we see new states added to the list and they have their own requirements, what companies should be doing there is really just making adjustments or tweaks to their program, right? But the base itself should be in good shape. And that's something that we do as a company. We monitor when new states come on board and then make adjustments to our program as needed. So I will open it up to questions if there are any.
Thanks, Eric. Do have a clarifying question here. These various state privacy laws that you've gone over, do they apply to any company, or is this just unique to those in the healthcare space?
No, it's certainly not limited to the healthcare space. It applies to really any business that doesn't fit within one of those exemptions. And we talked about HIPAA and GLBA and some of the other exemptions, but really any business that doesn't fit within one of the exemptions and satisfies one of the criteria, such as operating in the state, targeting individuals in the state. And again, sometimes there are thresholds for how many residents in terms of data and so forth, but it's certainly not healthcare specific. It's much broader than that. It's really any business that hits the criteria.
I see a growing need for more compliance officers in the United States then.
Yeah. Yeah.
Another question then, in your opinion, are these states enacting these laws because they don't feel like the federal government is quite doing enough? Or has this always been, in Europe, we have GDPR, or at least in Great Britain, we have GDPR, which covers the whole country. But here we're taking a state by state approach. Is that just the dynamic of the United States?
Yeah, it certainly seems to be right now. That's certainly true. In Europe, we have GDPR, which is very broad. UK has something similar, UK GDPR, and in many countries that have enacted privacy laws since GDPR, it has been sort of at the country level, right? Sort of a federal law, if you will. But we're not quite at that point yet, and so that is sort of the prevailing opinion, is that in the US, states are really, until we have a federal privacy law, states are taking matters into their own hands, and because there is some concern that that we see at the state level. They want to ensure that consumers have certain rights over their data, that businesses are processing personal data appropriately and under the right safeguards and so forth.
Great. That was it for questions. Thank you so much, Eric. And
Thank you.
Aaron, if you could switch to the next slide, thank you. Folks, I just want to again reintroduce myself. I'm Sabrina Viano. I am the National Vice President of Client Development, and I wanted to take a second to thank our speakers. As you can tell, at UHC Global, we have a very good legal team. This is about half the team that was represented today. And they provide us with a tremendous amount of advice and certainly keep us compliant. We also have a really good sales team. And so there were some questions in the chat about who to reach out to. So I think this slide is valuable. This shows our map, if you will, and who to contact. So our audience today is mostly insurance brokers. And we connect you with your sales VP by your state location. So in the gray, if you're anywhere in the West Coast, we have two gentlemen that can help you, David Galino and Travis Tushek. In the Central and Southeast regions, you can reach out to Susan Deschesre. In the Northeast, we have our host here, the host with the most, that's been on the line, and that's Greg Ruggiero. And then in the Mid-Atlantic and the Carolinas, you can reach out to Bill Marble or always myself. And we're happy to connect with you, talk about our expat TCN products, as well as our short-term business traveler products, see what your needs are. And at the beginning, Sarah Dubinsky, our first attorney that you heard from, she mentioned the quarterly newsletter that our legal team produces. One just came out yesterday, so you should receive it very soon from your local sales VP. However, if this is something that you know you aren't receiving and you'd like to be on these updates, please reach out by email to the person that you see here on the slide that works in the state that you're in. I'm going to turn it back to Greg. Thank you, everybody.
All righty. Yes. Thank you, Sabrina. And I'll bring us home here. Before we wrap up, I want to remind you that this webinar will be available for viewing after the call. You'll receive an email with a link to access it. Additionally, please look out for a survey sent afterwards, maybe even included in that email. We really value your feedback, and we would like to know what you found valuable out of this, and maybe what topics you'd like to like us to cover in future webinars as well. Thank you again for spending your valuable time with us here today. We appreciate it and look forward to seeing you soon. Bye.